gets to decide who prosecutes federal crimes in New Jersey? The courts or the president or the mob? That's the central question in a high-stakes legal battle over Alina Habba, Donald Trump's former personal lawyer turned acting U.S. attorney. After a federal judge panel rejected her reappointment and appointed a career prosecutor in her place, the Trump administration quickly fired the court's pick and reinstated Habba through a different legal mechanism. This procedural shell game now threatens to derail key criminal prosecutions and challenge boundaries of executive power. So, just another day in Trump's second term. This dispute involves major questions, like a federal court's authority to appoint a U.S. attorney, whether the Attorney General is permitted to fire a court-appointed U.S. attorney, and of course, whether Habba still has her job. So today, I'll dive into the murky legal waters presented by the Habba mess. Okay, let's set the scene for this unusual legal dispute. On March 24, 2025, President Trump posted on Truth Social that he was appointing Alina Habba as interim U.S. attorney for the District of New Jersey. Her 120-day tenure was set to expire in late July unless she was confirmed by the Senate. The Habba pick was controversial, in part because Habba has no prosecutorial experience, and in part because her work as a member of Trump's civil defense team was, shall we say, just a bit outside the norm.
Vaughn into the windup in his first offering. Just a bit outside.
When Habba met Trump, she was in the minor leagues, leading a small firm in suburban New Jersey. She previously served as general counsel to a parking garage company that was owned by her husband. Habba proved herself to Trump by inserting herself into the sexual harassment case of 20-year-old server Alice Bianco, who worked at Trump's Bedminster Golf Club. Bianco alleged that her manager sexually harassed her and that after she rebuffed his advances, he retaliated against her. When other employees described this toxic workplace to HR, Habba entered the picture, communicating directly with Bianco despite knowing she had legal counsel. That's a big no-no. Habba pressured Bianco to fire her lawyer, sent texts undermining his credibility, and ultimately advised her to ignore him altogether. Soon after, Bianco signed a non-disclosure agreement prepared by Habba, which contained illegal confidentiality clauses and harsh financial penalties for speaking out, despite New Jersey law making such provisions unenforceable in harassment cases. This conduct arguably violated many ethical rules, like communicating with a person she knew was represented by counsel while actually representing the interests of an adverse party. It's also pretty bad to draft an NDA that's illegal under New Jersey law. But as we all know too well, what sounds bad to legal ethics committees is music to Donald Trump's ears. And so Habba entered the big leagues as a fixture of his civil defense team. As Liz Dye explained, Habba's major accomplishments for Team Trump consisted in getting fined nearly $1 million for filing a frivolous lawsuit against Hillary Clinton and getting reprimanded at least 14 times in a single day during the E. Jean Carroll defamation trial. While all that may not look good on a conventional resume, Trump values loyalty and ethical flexibility above all else. After Trump's election, Habba served as counselor to the president. On March 24, 2025, Trump announced that he was appointing Habba to be the interim U.S. attorney for New Jersey, effective immediately. New Jersey's two Democratic senators were not pleased. On July 1st, Trump formally nominated Habba to serve as U.S. attorney for New Jersey, but the Senate never considered her nomination. Meanwhile, Habba's 120-day interim term was set to expire on July 22nd. On July 22nd, a panel of U.S. District Court judges invoked their power under federal law and declined to extend Habba's interim term. They voted to replace Habba with Desiree Grace, a longtime federal prosecutor whom Habba chose to be her first assistant. 2 days later, on July 24th, President Trump withdrew Habba's nomination from the Senate. This was a strategic move that allowed Attorney General Pam Bondi to fire Grace and reappoint Habba as the first assistant, which, like a legal Pez dispenser, automatically caused Habba to move up to be the acting, not interim, acting U.S. attorney for up to another 210 days, despite lacking Senate confirmation. So was any of this legal? To find out, we need to look at three sources of law: the Appointments Clause of the U.S. Constitution, the Federal Vacancies Reform Act of 1998, which we're going to call the Vacancies Act, and 28 U.S.C. Section 546, which we're just going to call Section 546. Let's start with the constitutional text, since it sets the stage for everything. One key legal question is whether a U.S. attorney is considered a principal officer or an inferior officer. And why does that matter? Because under the Constitution, principal officers like cabinet secretaries must be nominated by the president and confirmed by the Senate. Inferior officers, who are lower ranking, can often be appointed by courts or department heads without Senate confirmation. If a U.S. attorney is a principal officer, then only the president can appoint or remove them. But if they're an inferior officer, courts may have the authority to appoint someone temporarily, which is what happened in this case. So the distinction shapes really who has the power to decide who prosecutes federal crimes. I know we're all hoping that the question has an easy answer, but then we wouldn't have a channel. Well, let's look at the text of the Appointments Clause. Article 2, Section 2, Clause 2 includes the following. He, meaning the President, shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. So, who are officers? Well, notice the text specifies two different types, officers and inferior officers. The first type, usually called principal officers to avoid confusion, has referred to high-level executive officials like cabinet secretaries, the Secretary of State and the Secretary of Treasury, or heads of independent agencies like the Federal Election Commission or chairs of the Security and Exchange Commission. Basically, people exercising significant authority pursuant to the laws of the United States, as the Supreme Court said in Buckley v. Vallejo in 1973. Importantly, as the clause says, while the President always has to be the one to appoint principal officers, if Congress chooses to do so, they can vest the power of appointing inferior officers in lower-level officials. Inferior officers aren't defined or delineated from principal officers by any specific criteria in the constitutional text. As the Supreme Court said in Morrison v. Olson in 1988, the line between inferior and principal officers is one that is far from clear, and the framers provided little guidance into where it should be drawn. The Morrison Court helpfully provided some clues of inferior status. The officer can be removed without cause by a higher-level executive official, can only perform certain limited duties, or has a limited or time-bound tenure. In Edmund v. United States in 1997, the Supreme Court said that, generally speaking, inferior officers are officers whose work is directed and supervised at some level by others who were appointed by presidential nomination with the Senate's advice and consent. Unhelpfully, whether U.S. attorneys are principal or inferior officers is not 100% clear. On the one hand, they're nominated by the President and appointed subject to Senate confirmation and possess significant independent discretionary authority. On the other hand, they're subject to oversight by the Attorney General, and their authority is geographically constrained to their district. So the prevailing view is that they're probably inferior officers, but it's a slightly open question. So let's look at our cast of characters so far. Donald Trump is the President of the United States. Again. Alina Habba is, well, was, actually, we'll get there, his nominee for U.S. Attorney for the District of New Jersey. Here's two senators, Cory Booker and Andy Kim, who want Trump to pick someone else, and so aren't exactly rushing to vote to confirm because they're concerned she's an unqualified hack. My words. Who does not meet the standard to be a U.S. Attorney, and who, in her short tenure as an interim U.S. Attorney, has degraded the office and pursued frivolous and politically motivated prosecutions. Booker and Kim's words. To zoom out just a little bit further, note that it's standard practice for U.S. attorneys appointed by one president to resign their posts if the president from a different party is elected. That's what happened after Joe Biden's loss last November. His appointee for the U.S. Attorney for New Jersey, Philip Selinger, submitted his resignation on December 8, 2024. This left the office vacant. And that's where the second piece of law comes from. 28 U.S.C. Section 546, which deals with vacancies specifically in U.S. attorneys' offices and nowhere else. Section 546 empowers the Attorney General to appoint an interim U.S. attorney when the office is vacant.
Now, despite the fact that the political and legal maneuvering brought prosecutions to a halt, this story was dramatically underreported. Taking a look at these specific stories, you see a fascinating breakdown of how attitudes across political divides are rapidly changing. Now, there were only 87 reports about Alina Habba being reinstated as U.S. Attorney for New Jersey, with 33% of the coverage coming from the left, 40% from the center, and only 25% from the right. On the left, sources mostly frame the story as Habba coming back through a shady or illegal move. On the right, sources largely highlighted the administration not backing down and framed it as a generic power struggle with no recognition of what the law actually allows. Now, the headlines and coverage vary greatly depending on the source, which is exactly why I love today's sponsor, Ground News. LegalEagle to get 40% off a Ground News Vantage subscription. You can just scan the QR code on screen or click on the link in the description to claim your discount. The Nobel Peace Center called Ground News, quote, an excellent way to stay informed, avoid echo chambers, and expand your worldview. And I couldn't agree more. They've been a longtime supporter of this channel and of independent journalism at large, so please consider checking them out. Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. Now, one of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. For example, we've seen a lot of stories about Jeffrey Epstein, and there are a lot of blind spots, like the story about 63% 53% of registered voters disapproving of Trump's handling of the Epstein files, which was largely ignored by left-leaning media, or this blind spot, Trump announcing we will forever call this, quote, the Epstein hoax, a story that got less than 10% of right-leaning sources reporting, suggesting an unwillingness to buy into the idea. Now, these gaps in coverage are exactly why Ground News is my favorite way to stay informed. And just to repeat, Legal Eaglets get 40% off the Ground News Vantage subscription. You can scan the code on screen or click on the link in the description to start your subscription today. You'll get unlimited access to every feature, including the Bias Insight tool and the blind spot feed. And by subscribing, you'll also be supporting an independent platform that's trying to make the media landscape more transparent and balanced. So scan the QR code or click the link below, or I'll see you in court.
The Attorney General is not allowed to appoint a person who was previously nominated to that office but rejected by the Senate. An interim U.S. attorney can only serve for 120 days or until the Senate confirms a nominee, whichever is earlier. Most importantly, if the 120-day clock expires, the district court for such district may appoint a U.S. attorney to serve until the vacancy is filled. Section 546 adds 2 more characters to our cast, the Attorney General and the district court. Here's Pam Bondi, Trump's Attorney General, definitely a principal officer who's confirmed by the Senate. And here are the judges for the United States District Court for the District of New Jersey. Not really. I couldn't find a picture of all 17 of them together. Congress specified in Section 546 that it's okay for someone other than the president to appoint an interim U.S. attorney, which means, at the very least, that interim U.S. attorneys are definitely inferior officers, and also that they can be removed at will by the figure who appointed them. Trump publicly announced Habba's appointment on Truth Social on March 24th. It is with great pleasure that I am announcing Alina Habba, Esquire, who is currently serving as counselor to the president and has represented me for a long time, will be our interim U.S. attorney for the District of New Jersey, her home state, effective immediately. Trump announced it before Bondi did the paperwork, which raises questions about which date starts the 120-day legal clock. Under Section 546, it would seem that Trump can't appoint an interim U.S. attorney, since in the law itself, Congress vested that power in the Attorney General. Normally, we might say that, functionally, this doesn't really matter. Hypothetically, Bondi could have just said, yeah, Trump announced it on the 24th and said it was effective immediately, but it was my call to do it, Habba was my choice. But we're dealing with a ticking clock here, remember, 120 days. And it turns out that whether it was effective immediately after Trump's announcement on the 24th or the day after Bondi's appointment on the 27th is pretty significant. If Habba's interim appointment was actually effective immediately like Trump said, then this appointment should have expired on July 22nd. But if Bondi's order, which specified Habba's appointment would begin the following day on March 28th, was the true effective date, then the interim appointment expiration would be July 25th. This matters. In either case, soon after her interim appointment, Habba handpicked a first assistant to serve as her deputy, Desiree Grace, a career civil servant who'd been serving the U.S. Attorney's Office for New Jersey since 2016. On July 22nd, Habba's 120-day term apparently expired. And so under Section 546, the judges in New Jersey's federal district court exercise their prerogative to appoint a United States attorney to serve until a vacancy is filled. This wasn't really a surprise. According to the New York Times, in a staff meeting a little over a week prior, Habba acknowledged that she was unlikely to be appointed by the judges and offered an emotional, preemptive farewell. And she was right. In an order signed by Chief Judge Renee Bum, the court declined to extend her interim appointment and instead appointed First Assistant Grace, effective July 22, 2025, or upon the expiration of 120 days after appointment by the Attorney General, whichever is later. Then all hell broke loose. Later that day, Deputy Attorney General Todd Blanche tweeted, "The district judges in New Jersey just proved this was never about the law. It was about politics. They forced out President Trump's pick, then installed her deputy, colluding with New Jersey senators along the way. It won't work. Pursuant to the president's authority, we have removed that deputy effective immediately. This backroom vote will not override the authority of the chief executive." Bondi also chimed in. "This Department of Justice does not tolerate rogue judges, especially when they threaten the president's core Article 2 powers." But that's wrong for at least 2 reasons. First, the New Jersey District Court judges didn't go rogue. Section 546 clearly and specifically allows for district court appointments when an interim U.S. attorney's 120-day term expires. That provision exists for a reason. It's meant to pressure the executive to nominate someone and get them confirmed. If the president fails to do that in time, control temporarily shifts to the judiciary. Second, even if Grace was removed as first assistant, the court could still appoint her since she's qualified and the law allows the court to appoint anyone. If Bondi was attempting to remove Grace as interim appointee by herself, she can't. She has no authority to do that. Generally, the power to remove follows the power to appoint, and Bondi didn't have the appointment power, which was used to appoint Grace. In a new court filing, the Trump administration refuses to concede that Grace's appointment was ever valid, so the closest thing to a firing is 2 government officials notifying Grace on July 26th that Trump would remove her if somehow her appointment were effective. In addition, many such appointments have been made over the years. A similar situation came up in 2020 when the Trump administration forced out Jeffrey Berman, a court-appointed U.S. attorney in New York. The removal was legally murky, and Berman initially resisted, but he ultimately stepped down after Barr claimed the president had authorized it. That case wasn't litigated, but it's now being used as precedent to argue that Trump can remove Grace as well, which would allow Habba to resume the job under the Vacancies Act. That's a plausible reading of executive power, one echoed in Office of Legal Counsel opinions. A 1979 OLC memo indicates that the president probably would have the power to remove Grace despite the district court's appointment if he wanted to, but Bondi would not be able to on her own. But Berman's removal was never tested in court. Okay, I regret to inform you that things are about to get even more complicated. So, the Trump administration's story is that Grace was fired as first assistant on July 22nd and that Habba's 120-day term was set to expire on July 25th. That on July 24th, Habba sent a letter informing Bondi that she was resigning her position as interim U.S. attorney effective at 5:00 p.m. today, and that later that same day, Bondi issued an order appointing Habba as a special attorney to the U.S. Attorney General and designating her as first assistant to the District of New Jersey, the same position that Grace had been serving in days earlier. As first assistant U.S. attorney, this order says Ms. Habba will have the authority to serve as acting United States attorney upon a vacancy in that office subject to the conditions and time limitations of the Federal Vacancies and Reform Act of 1998. This is our third and final piece of law, the Vacancies Act starting at 5 U.S.C. section 3345, which concerns acting officers. The Vacancies Act is much broader than section 546. Section 546 is specific to U.S. attorneys' offices, but the Vacancies Act covers the entire government, including U.S. attorneys' offices. As a practical matter, an acting officer under the Vacancies Act has the same authority as an interim appointee under section 546, but is subject to different time limitations, 210 days instead of 120. One other difference. While Section 546 empowers the Attorney General and sometimes the court to appoint an interim U.S. attorney at any given time, Section 3345 of the Vacancies Act automatically makes the first assistant the acting U.S. attorney as soon as there is a vacancy. Because, of course, someone has to be in charge at every moment. There can't be a gap in authority. This explains the elaborate song and dance of firing Grace, having Habba resign from interim status, rehiring Habba as special attorney, and then instantly promoting her to first assistant. Under the Vacancies Act, the first assistant automatically assumes acting status when there's a vacancy. Recall that the district court's order appointing Grace under Section 546 made the appointment effective July 22nd or 120 days after appointment, whichever is later. The administration's theory then is this. Bondi's order naming Habba the interim appointee on March 27th was the real one, meaning the 120-day mark wasn't until July 25th. By finishing the whole song and dance before the end of the day on July 24th, they beat the district court to the punch by a few hours. That's their story and they're sticking to it. But the Vacancies Act has more. A person is barred from serving as an acting officer when two conditions are met. First, if in the year preceding the vacancy, the person either did not serve as first assistant or served as first assistant for less than 90 days. Second, if the president submits a nomination of such person to the Senate for appointment to such office. Well, wait a second. We know that Habba had been nominated to the Senate on July 1st, and the vacancy occurred when the Biden-appointed U.S. Attorney Philip Selinger resigned. Since Habba hadn't served as first assistant prior to the vacancy occurring, that subsection seems to disqualify Habba right there. If Trump hadn't also withdrawn her nomination pending Senate confirmation on the same day. But a spokesman for the Justice Department said Thursday that the White House had withdrawn her nomination, allowing her to serve as acting U.S. attorney. It seems like the administration has given up trying to have Habba be the real deal nominee at this point, and instead is going to see how long they can just keep her around as a temporary time-limited official. But there's another wrinkle. It's arguable that under the Vacancies Act, if the president nominates someone for a role once, that person becomes forever ineligible to serve in that role in an acting capacity. The Vacancies Act makes someone ineligible to serve in an acting capacity if the person submits a nomination of such person to the Senate and the other condition applies. And Trump did exactly that on July 1st. The law does not say anything about withdrawal of nomination, just submitting it. Defense lawyers in New Jersey are using that exact argument, saying Habba is barred from acting as U.S. Attorney for New Jersey, period. The leadership limbo is having tangible consequences for New Jersey's federal court docket. You see, Section 3348 of the Vacancies Act voids all actions taken by improperly serving acting officials. Every charging instrument in every criminal case is signed under her purported authority. If her appointment is found to be a Vacancies Act violation, all of those charging instruments go poof. All of the trials, guilty pleas, motions, responses shall have no force or effect. Already, a triple homicide trial and dozens of other cases have been delayed, with defense attorneys estimating that more than 1,500 active federal cases could ultimately be affected. The Justice Department insists that Habba's appointment is lawful, and that even if overturned later, prosecutions conducted under her tenure remain valid under the de facto officer doctrine. Many documents issued by her office now include a so-called de facto officer disclaimer just in case Habba's appointment is later deemed invalid. Which, no. The de facto officer doctrine is a common law doctrine that allows courts to validate the past actions of an improperly serving official. Common law courts have applied this doctrine for nearly 6 centuries. Think of it like this. You have someone who has been serving in an office, getting a lot of work done, everyone thinks they belong there and is relying on their actions, and blam, some legal technicality says they were never properly appointed. The de facto officer doctrine is a common sense solution born out of a desire and need to protect the interests of the public and ensure the stability of government functions over time. There's no definitive test for application of the de facto officer doctrine. It's a common law doctrine responsive to equities. But at its most fundamental, the de facto officer doctrine will only validate the past actions of an improperly serving official who was widely believed to be properly serving and doing so in good faith. Once it's known that an officer is improperly serving, or once questions are widely raised about the propriety of that officer's appointment, the de facto officer doctrine is no longer available. And I think we're there. I mean, we made this video. New York defense attorneys are sharpening their knives and filing their motions. As the New York Times reports, U.S. District Judge Edward S. Keel recently said in a hearing related to a motion arguing that Habba was appointed unlawfully, "At this point, as I said, you'll see, generally, that a lot of judges will not be hearing any criminal cases that are of a non-urgent matter. Because, for example, if we take a plea today and that motion is granted, I don't think that the plea colloquy today and what the United States Attorney does here in this case would be effective, and we would have to redo all those things." Judge Keel then transferred the motion to Chief Judge Matthew Brann in Pennsylvania, and the Third Circuit Court of Appeals has placed the question of Habba's acting appointment on an accelerated docket, promising a binding, precedential ruling within months. Whatever the outcome, this dispute is poised to clarify just how far a president can go to hold on to favored prosecutors and loyalists.
Now, if you're facing a criminal prosecution, whether your prosecutor was validly appointed or not, you're going to want a good lawyer. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who were dealing with legal problems. People would DM or email and ask if I could help them find a lawyer, or how do they know if their attorney was any good. And there's just a massive gap in our justice system. It's not just that legal help is expensive, though it absolutely is. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up either doing nothing or hiring the first attorney who calls them back. And that really bothered me. And so I asked myself, what if there was a different way? What if we could build a law firm that actually lived up to the values I talk about on this channel: transparency, accessibility, and putting clients first instead of just chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix the problem. I decided to start my own personal injury law firm, and honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. And that's why we started the law firm Eagle Team. Not to get rich, trust me, there are easier ways to make money than starting a law practice, but we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer, you're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, not just whoever happens to be available, located right where you are. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, or a social security or workers' comp issue, give us a call at the number on screen or click on the link below. I can't represent everyone who watches this channel, I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partner with, you'll get the same principles of honesty and education that we bring to every video. So if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about. Making sure that when life gets complicated, you don't have to face it alone. Which is why, if you need a lawyer, you don't just need a legal team, you need the Eagle.